teenage boys, for example, who abuse animals, that can lead to more serious crimes, including sexual or violent tendencies. A lot of serial killers started out killing animals and abusing animals as a result of that. That I've reviewed and the information that was supplied, there is an issue. So, if Mr. Bloom is serious about seeing his children, he might want to address some of those. All right, counsel, I'm going to ask you to make an opening statement because my review of the file shows that there was a final order entered in a divorce action in Montgomery County back in 2020 by Judge Closure that designated them as equal residential parents and had a 50-50 division of time. And since that time, it's my understanding there was an order of protection that was issued in this case. Is that one of the issues that we're dealing with today?
It would be, Judge, but there's also a juvenile court case that's happened since then, and jurisdiction was relinquished back to this court. That's why Mr. Parks is here. He was the guardian ad litem for the children. That was in April through December of 2024.
Right. And so what are we fighting over today?
Well, if I just may briefly, Judge, the order, the juvenile court case dealt with some issues that were going on in Dad's home. He was married to his wife, Lacey, his former wife, Lacey, at that time. She's actually here. They divorced. There was an incident that happened with Levi. As a result of that, my client filed an emergency custody petition. That matter was heard and the children were removed from the father for a period of time. Through in December, he was granted some sort of limited visitation that wasn't every other weekend. I had that final order and then relinquished custody back to this court. Then he started having issues in his marriage. He divorced his wife. There were some concerning behavioral issues that happened with Dad. He was actually living out in the woods for a period of time. There were some things with animals that happened. He has not seen these children since December of 2024. He stopped paying child support. My client had to move to Michigan. I filed a notice of relocation with the court. He stopped paying child support. So there was an arrearage in child support, and he's not seen these children since December of 2024. These children are now 14, almost 15, and 12, almost 13 are both here and do not want to have contact with their father. They're afraid of their father. The ex-wife is here to talk about some substance abuse issues and some concerning behavioral issues. And we would ask that there is no contact with the father.
Space.
It's my client's position that mother has continuously and systematically used the system in Montgomery County and in Stewart County to limit my client's contact with these minor children to get what she wants, which is ultimately to move to Michigan to be with her boyfriend. And that's what she's done. She's accomplished that. And quite honestly, them now coming and saying they've had no contact with their father since December of 2024, they've been coached to say these things. It's my client's position. He needs to have a way back to continue to get contact with them, to be able to foster a relationship with them. Mother clearly doesn't want it. I think that the next step would probably be for mother to isolate father even further from these children so that her husband, when she marries, can then adopt the children and completely cut father out of the situation. Yes, he went through some issues. We'll address those issues in the testimony that he's going to provide today, but there's no reason that this order of protection should stay in effect. The allegations that were raised, I believe the order of protection was filed in early 2025. That's what's in place right now, is that order of protection.
The order of protection that was issued by Judge Brigham expired on March the 3rd of 2026. So there is no pending order of protection.
There was another one that it looks like was filed by mother. Was another one that was filed March 4th of 2025.
And was there a temporary, I don't have a copy of that. Was that in general session?
Maybe. Yep, and it looks like it might be. I don't believe there's ever been a hearing on this.
Right, and this one is based upon, at least partially upon, the allegations that were involved in his prior relationship, prior marriage, in which there were animals involved.
Specifically, it says in there that there's no known harm to the children.
Right.
So again, we believe that this is mother methodically laying cases out in front of multiple courts to limit father's time. And that's what she's continuing to do. All we're looking for is a way back for these children and father to foster a relationship.
All right.
And if I may, I can pass forward the last order from the juvenile court, which set forth that father it was in April of 2025. Father had not visited with the children since December of 2024. And that's when the court relinquished jurisdiction back to this court. I think that would be helpful for them.
All right, we'll let you go ahead and mark that as exhibit 1 to this hearing. So that we're all clear, there is a pending appeal on the order of protection that was issued by Judge Brigham in March of 2025. And that has not yet been heard by this court or any other court. And therefore, we'll have a hearing on that order of protection. Then the other issue is the request for relocation. There is no pending petition to modify the parenting plan, if I recall correctly. Is there a?
Yes, there is. It was transferred from Montgomery County. It was filed in Montgomery County and they transferred it to. I have the order transferring it to Stewart.
Well, I've seen the order transferring.
Here's
No.
the petition that was filed back in November of 2024, Judge.
Okay. Maybe what I missed.
Sorry. I just assumed they sent it down. I'm assuming if you didn't have the petition, you don't have Ms. Bates' answer that she filed on February 15th. After I file a motion for default.
I'm looking. I don't see the first thing that's in this court file is a notice. Is a notice of filing in June of 2025. The notice of the motions or the notice to relocate. I do have the order transferring, with the order transferring it signed by Judge Alita. And it basically transferred the entire file, but I'm not seeing, and maybe it's out of order, is your petition for modification.
And it was based on the things that happened with juvenile court and him not seeing the children and things of that nature.
Step off. I just want to make sure we've got it in the correct order. So I'm gonna, would you look to see if your file has this information in it, with the notice of appeal on that one? let's take a short recess and let her, I want to make sure the file is reflecting what we're fighting over today.
All rise. Stated that earlier. Whenever we have something that, that's the reason why I always like to keep it available. Causes that. If we want home there, we have to stay on that side. Safe as it's still out of size cover. It's just something we hate to do. So, oh. But that, because of, depending on the judge, it can be considered as messing with their perspective on the case. Yeah. Could be, and that's what it is, you know what I mean? All rise. We're back in session. See you come over.
All right, let me say this to the parties, Ms. Wyman and Mr. Blue. This case originated, as you both know, in Montgomery County, and it was transferred over here by an order of Judge Alita. And normally that's not a problem, except for the fact that they didn't transfer the entire file. Therefore, I do not have in our file a petition to modify the parenting plan that was originally adopted. And I cannot rule on matters that are not properly before me because my jurisdiction extends to what's in our court file, not what's in another county's file. So as a result of that, I necessarily have to continue your hearing. I don't really want to do that, but I don't really have any choice. And as a result of that, the next available date that I have, and I've gone over it with your lawyers, is my next regular chancery day, which is August 4th. Now that's a long way away. In my opinion, in this case, there needs to be the reappointment of the guardian ad litem that was appointed in juvenile court. So I'm going to reappoint Mr. Charles Parks, who was here this morning, to be the guardian ad litem in this court as well. In addition to that, you've got teenage daughters, and while they are expressing a preference regarding that, it is not a simple thing for this court to simply say that a father can no longer see his children, period. Although there may be issues that have arisen in the past, there are instances where there have been abuse of children, and we still are required to allow the children to have some sort of therapeutic visitation with the minor, with them. Ms. Wyman, if you'll stop what you're doing so you can listen to what I'm saying. It's very important for two things. Number one, the children need to understand that the law says Mr. Blue has a right as a father to see his children. Termination of the parental rights is one of the most important and significant things that can occur in the courtroom. We had that this morning, and it requires a finding by clear and convincing evidence, which is the highest standard for evidence, that it's in the best interest of the minor children to terminate the father's rights. So under these circumstances, there are issues clearly, and that he's not seen the children, allegations about parental alienation and so forth, to identify what the issues are between you and your daughters and to try to protect their best interest as well as balancing that against your right as a father. I'm going to order that these children be, that there begins some sort of therapeutic counseling between you and your daughters and a therapist. Dr. Charles Ehrig, I think both of your lawyers are, Ehrig may be the right way to pronounce it. He is an expert witness in many cases in this court. Both of your lawyers are familiar with him. If the girls live in Michigan, then there should be an ability to do a telehealth type of a situation where they can do that by Zoom if necessary, and that will allow him to make an assessment. But in order for me to make an informed decision regarding what's in the best interest of your daughters, I need some expert testimony regarding what is in their best interest from a person who deals with this on a regular basis. Dr. Ehrig's responsibility will be to talk with the children, determine what is in their best interest, and then make that recommendation to this court. So as a result of that, this court is of the opinion that there should be an order down ordering that the therapeutic visitation or therapeutic counseling, it will not be visitation, but therapeutic counseling with Dr. Ehrig and the parents can all be arranged. Now, what that necessarily means is that your daughters are going to be involved in talking to Dr. Ehrig. So as a result of that, it is a difficult balance you strike not to talk about this case with the children. The main thing we don't want to do is to give any ammunition to Mr. Blue that says that the children are being influenced. And there are subtle ways to influence children, but I think under these circumstances, we just need to have a rule that the children will not be involved in any discussions about this case, other than the fact that this is what the court has ordered regarding Dr. Ehrig's counseling, and that is a mandatory thing that they're going to have to enroll in. But beyond that, talking to the kids about what their preferences are and so forth, we'll get to that eventually. And we have a guardian ad litem. Let the guardian ad litem speak for the children and let them communicate with him so that he's fully informed as to what their position is. That's his whole purpose, is to determine what's in the best interest of the children. But putting the children in the middle and asking them to pick or choose or trying to influence them just makes things more difficult for them, in my opinion. So we're going to try to protect them the best we can from having to be exposed to that. Under these circumstances, I'm sorry I cannot go forward with it today, but I do believe that this is in the best interest of your children to do that. So, anything else before we adjourn?
With Dr. Ehrig, I've also had a lot of experience with his reports. He does like non-self-reporting type situations where he speaks to other individuals, such as both parents and other individuals, to get a background with regard. He does Rule 35 evaluations with regard to mental health evaluations. And we think that's critical in this particular case, that as part of this, we look into Mr. Blue's mental health.
There's been no Rule 35 request that's been filed, so you would have to file a motion for a Rule 35 evaluation for me to make a determination. Again, I can't rule on something that's not before me, but I understand the basis for your saying that, and I understand the reasons why you would suggest that. And clearly, that I've reviewed and the information that was supplied, there is an issue. So, if Mr. Blue is serious about seeing his children, he might want to address some of those situations, either with Dr. Ehrig or someone else, so that there can be some evidence that as to what he's dealt with. There is clearly a pattern in teenage boys, for example, who abuse animals, that can lead to more serious crimes, including sexual or violent tendencies. A lot of serial killers started out killing animals and abusing animals as a result of that. So let's get that, taken care of, but I do not have an order. I do not have a motion for Rule 35 evaluation, which would be court ordered, but Mr. Blue, if he's willing to try to help the court in making a determination regarding his children, obviously it would be in his best interest to try to address that issue. All right. Then this matter will be reset for August the 4th. And Ms. Turner, you're the moving party. I'm going to ask you to draw an order that reflects what I've been.
I will do that, Judge. Underneath.
Thank you. Yes, ma'am.
The children are here today. Father has not seen them since December of 24. He would just like the opportunity to say hello to them.
The daughter's, it's a daughter and son. The daughter is crying, no, she does not want to talk to him today. You know,
If the son is here, the son, I mean, any contact he can have with these children, he's.
Contact Mr. Parks, who is now the guardian ad litem. Tell him what the situation is, see if he can talk with the children to determine whether or not they're willing to do it. Forcing teenage kids who don't want to do something to do it may be counterproductive for Mr. Blue. But they need to know that he would like to see them and like to have an opportunity to talk with them. So I think that Mr. Parks, who's here in town, could come back over and talk to the kids and then why don't, before you leave, since you were going to be here most of the morning anyway, why don't, before you leave, let's see if you can't get something worked out. Maybe Mr. Blue can just say hello to them if anything, but I think they do need to know he wants to see them. It is a difficult thing for a child to process, in this court's opinion, that when they haven't seen someone, one of their parents for a long time, they don't necessarily understand why that has happened. And oftentimes they will think it's because that parent does not care about them. So letting them know that he does care enough to wants to see them would be, in my opinion, something that would be beneficial to the children. Whether they then say they want to see him or not, at least let them know that he wants to see them. All right, we stand adjourned.
All rise.
I don't know that I have this.
I just text him, tell him to come back over.
Thank
Hey,
you.
Okay. Yeah, we're gonna vote.
all rise. Judge Court Stewart hands down, session down with Judge Wolf presiding. All those business done now shall be heard. God bless the country, the state, and the son of the court. Please proceed, come to order.
You're unmuted, right? Excellent. All right, good morning. We'll start with the call of the docket.
In the matter of Noah Hoosier.
Morning, Judge.
Morning.
Have petitioner Miss Berry, and she did seek an emergency conservatorship. This time it is no longer necessary and she wishes to terminate it. We did prepare an agreed order and had the respondent sign as well. Would you like to hear some text from Miss Berry?
Let's go ahead and have a place under oath and let you put on your proof.
You solemnly swear or affirm the testimony you're about to give us the truth, whole truth, nothing but the truth, so help you God.
State your name and your relationship to his wife.
Kimberly Berry, I'm his mother.
And you sought the emergency conservatorship for temporary reasons. Is that right?
Yes, correct.
And is Noah doing better?
Yes,
And is it your choice to terminate the temporary conservatorship and not pursue the permanent conservatorship?
yes,
And did he enter into a general durable power of attorney,
yes,
meaning he was his agent?
yes.
And there's been no positions or statements providing that he needs a conservatorship. Judge, so.
All right. All right, I have signed your order.
Thank you, Judge.
Thank you.
The matter of Callie Settles and Kennedy Zanar.
Well,
All right, everyone who's going to testify in this case, raise your right hand and let's place you under oath.
You all solemnly swear or affirm the testimony you're about to give us the truth, whole truth, and nothing but the truth, so help you God.
Ms. Vaughn, you may put on your proof.
All right, Judge, if it's okay, I'd like to start with the termination portion.
That's fine.
Aaron, let's start with you. Has Troy Settles provided any financial support for the children?
Not consistently. My last payment was February 9th of this year.
Has he maintained regular visitation with the children?
Not at all.
When's the last time he saw them?
July would be July 2018.
So 2018.
Yes.
You mentioned about the financial support, so he made a payment. Was there difficulty in getting payments from him?
It was very inconsistent. There would be 6 months, 7 to 5, and 1 7 to 5.
And he's not attempted to visit with the children or provide further.
Not at all.
What is the relationship between your daughters and your husband?
I think of him as their father. He's been pretty much the parental for them this whole time.
Do you believe that terminating Troy's interest would be in the best interest of your daughters? And you provided the court with all the necessary documentation, and we had good service on Mr. Settles?
Yes.
The judge, we are asking to terminate his rights, failure to visit.
All right, it's my understanding he has not made anything more than what we would call nominal payments of support. Is that correct? Very inconsistent and very nominal. And then he has not had visitation for quite some time, extended period, more than 4 months prior to the filing of this. All right, then I find by clear and convincing evidence that under the statutory definitions, Mr. Settles has abandoned the minor children. Now you may proceed to go forward with the adoption.
Thank you, Judge. Number, would you state your name?
Ethan Gumbert,
And how long have you been in the children's lives?
9 years.
Can you describe the bond that you have with Callie and Kennedy?
I mean, they're just like my own biological children, really. They both call me dad. That's all they've ever known me as, so.
And so you plan to continue providing emotional, monetary support?
Absolutely.
And would you agree to ensure the stability and continuity in their lives as their father?
Yeah.
And are you aware that if you divorce, that you would be responsible for child support?
Absolutely.
And if you pass away, that these girls could inherit of your estate? Are you aware of that? Do you believe that this is in the best interest of your daughters?
I do.
Miss Erin, do you agree to have the children adopted by Ethan?
I do.
And do you want their names to be changed to Gumber? Judge, I have 2 witnesses as well.
All right, you want to put those witnesses on?
State your name
Greg Zonar,
and what is your relationship with the parties?
my 2 granddaughters, Aaron's my daughter, he's my son-in-law.
So you heard the testimony that they both provided. Do you believe this adoption is in the best interest of these girls?
Yes, ma'am, I do.
Thank you.
state your name and your relationship,
Kyle Anderson, a good family friend.
and you've heard the testimony of the Gumbers. Do you believe this adoption is in the best interest of these girls?
Absolutely.
All right, Mr. Gumber, my job here is to make sure that you understand all of the rights and duties and obligations you're assuming. Right now, you're a stepfather, which means that while you have obviously a role to play in the children's lives, by law, you're not required to support them. You're not required to be responsible for them. You could one day walk away and be free from any obligation. Not that you would, but you understand that.
Yes.
After today, if I grant this adoption, they're your children, the same as if they were born to you biologically. So you got two. I thought they were twins when they first walked up here because they're both beautiful blonde girls and they look like they could be sisters, and they are sisters. And as a result of that, I want to make sure that you understand they're now 11. Is that right? Or 10 and 9? 9 and 11. Okay. Which one is Callie? All right. And which one's Kennedy? All right. And they're going to be teenage girls at some point. You realize that, right?
Yes, sir.
And while they're cute, beautiful young women here today, young ladies, they're going to turn into teenage girls. And that means that you're going to be overrun with teenage boys at your house wanting to take these teenage girls out and so forth. And it's going to be your responsibility as their father to monitor and to pass judgment on all of these guys that show up at their house wanting to date your daughter. You understand that?
Yes.
There was a country song about I'm just sitting here cleaning my gun or whatever. So, ladies, you understand that means if I grant this adoption, that he will be your father, and therefore he's going to be able to say, you can either date this person, or you can say you don't get to date this person, or you do get to date that person. Like my mother told me one time, he said, well, you can date somebody else or you can stay home. So they do that from time to time. All of you understand the duties and obligations of Mrs. Gumber. You understand this is going to fix this situation where he'll be on equal footing with you regarding your daughters. All right. I find that by clear and convincing evidence that this adoption is definitely in the best interest of Callie and Kennedy, and I'm happy to grant your adoption. So,
Thank you.
Thank you, Judge. Is it okay that they get a picture?
yes. Let me sign this order to make it official, and we'll do that. So.
Yeah.
Why don't you ladies, do y'all get along well enough to sit in the same chair together? Okay. Have a seat right here in the big chair. We're gonna scoot you up there. One of you want to hold the gavel? There you go.
Look at that.
That's what we're talking about.
Come on up here. If y'all come around, if you want to go for picture, ladies.
Ready? Thank you.
You are welcome. Congratulations. Thanks, sir. Congratulations. Callie and Kennedy, I'll tell you what, I'll give you your own souvenir. There you go. It's like, you can use that in school. So you've got your own gavel.
That's cool.
All right. Congratulations. All of these people here for this adoption, tell them to come on up here and get their picture made together. So, anybody want to get a picture up here in front of the bench with the girls? If you do, come on up. We'll let you have that opportunity. So,
You all want a picture?
you want a group photo? Come on up.
They would like to do that. Thank you.
You wanna get in with it? I guess so.
No, I'll just I'll be the photographer.
You wanna get in? Come on.
If you two want to get right here and the
There you go.
girls
Come on up
in
here.
front of you.
I can come back up here and let the rest of them move forward.
Y'all. You
Mom
guys.
and Dad, Mom and Dad.
And then we're gonna get everybody else
Mom
ready.
and Dad, two kids come up here.
Callie, send it to her.
I guess they can.
And everybody else can just kind of filter us all around this area right here.
Come on, everybody, don't.
Oh, thank you.
Like one stand there and
We're
one
gonna get
stand.
everybody. In.
We may have to scoot. Just a little.
Come up here, anybody, the grandparents need to be up here.
Yeah.
Yes, grandparents, we need to be up here and stick around.
That's right, but keep the kiddos open. Yes.
Here. Yeah, I'm gonna try.
But I would have You see that, good luck.
Sorry. One, two, three. Just like seven.
If that doesn't turn out good, it's your fault. This is one of those. few things that my job is really pleasant, and so I'm happy to make it as comfortable as possible. Thank you. Congratulations, Grandpa.
I know, I got Yeah.
Their ice cream.
I have a 10-year-old granddaughter whose hair looks exactly like theirs. That's why I thought it was pretty interesting, so.
Yeah. Good family.
Okay, I think on that note, we're just gonna adjourn for the day and go home.
Yeah.
Good note to end on.
I was saying, based on what, all the joy and happiness here, I think we should just stop where we are and go home.
Gonna take a turn quick. Yeah.
Because I have a feeling it's gonna all be downhill from here.
Yeah. That's goes to the fees.
I'm gonna
I'll get you a copy
get
of
an
it.
address.
Yeah.
All right.
The estate of Luella Jane Miller.
Judge, the client is no longer communicating with me. We have sent numerous letters out. And so I have no choice but to ask to release this counsel.
All right. Your motion to withdraw being unopposed, I will grant your request.
Thank you, Judge. May I be excused?
You may. This one was Sunday, so. We'll fill in this one. Done.
This dramatic courtroom case centers around a woman who admitted to driving while impaired by drugs and crashing into a utility pole, causing major disruption and shutting down an entire city block. But the judge's biggest concern wasn't just the crash, it was what happened afterward. Despite being ordered to attend recovery meetings, she completed only a fraction of what was required and arrived in court without proof of attendance. As the judge questioned her commitment, the hearing quickly became tense. While acknowledging her personal struggles and responsibilities, the court made it clear that excuses would not replace accountability. In the end, the judge imposed strict probation, treatment requirements, testing, community service, and a strong warning: take recovery seriously, or risk facing much harsher consequences in the future. This case highlights the importance of a fair and balanced justice system. Throughout the hearing, the judge took the time to review the facts, listen carefully, and ensure that every decision was based on responsibility and the rule of law. Courts play a vital role in giving individuals a chance to be heard while also holding them accountable for their actions. The judge's approach reflected both firmness and fairness, demonstrating how the legal system works to encourage positive change while protecting.
What began as a routine drive on Interstate 94 quickly turned into a courtroom battle. Police officer King testified that he observed Crystal Rowan repeatedly drifting out of her lane and nearly exiting the freeway where no exit existed. Rowan argued that she was distracted, emotional, and unsure whether police lights were meant for her. Dashcam footage was played in court as both sides debated what really happened that night. After carefully reviewing the video and hearing testimony, the judge ruled that the officer had probable cause to make the traffic stop. The case then moved forward toward sentencing.